9-0. Not one justice disagreed. Not one. And right now, that single number is sending shockwaves through election offices, courtrooms, and state governments across America. Because here's what you need to understand. The Supreme Court almost never agrees unanimously on major cases. These 9 justices disagree on some of the biggest legal battles in the country. So when every single one of them comes together and issues an emergency ruling in just a matter of days, that's not normal. That's the court signaling that something is seriously wrong. In the next few minutes, I'll show you exactly what happened, why it happened so fast, and why this one decision could reshape election battles in states across the country. Stay with me until the end, because the final detail may be the most important part of this entire story. This case did not start as a big national story. It started as a normal disagreement over how a state's election map should look. But within just a few days, it turned into one of the most important election rulings in years. Let me walk you through it from the beginning, step by step, so you understand exactly why this matters. A while back, the Supreme Court had already made a major ruling about how redistricting cases, meaning cases about how voting districts are drawn, must be handled by lower courts. This wasn't a small detail. It was a full framework, a clear set of rules every court in the country was supposed to follow from that point forward. That framework said 3 things very clearly. First, courts must separate race from politics when judging a map. A map cannot be thrown out just because it helps one political party more than another. There has to be real evidence of something else going wrong. Second, courts must respect the normal, traditional rules of map drawing. Things like keeping communities together, keeping districts compact, and not creating unnecessary conflicts between sitting lawmakers. Third, and this is the most important part, a legislature's map cannot be thrown out simply because someone offers a different map they prefer. If challengers want a map removed, they have to prove that their replacement map performs just as well across every single one of these legitimate factors, not just the one factor that makes their case look strong. That was the rule the Supreme Court laid down. Clear, direct, no guesswork involved. Now here's where the problem started. A lower court, meaning a federal court below the Supreme Court, was given a new redistricting case to review after this rule had already been set. But instead of following it properly, the lower court did something different. It blocked the map drawn by the state legislature, the elected lawmakers, and instead kept in place an older map, one that had been drawn earlier by the court itself, not by any elected official. Think about what that means for a moment. A map made by judges was being kept in place, overriding a map made by the people's elected representatives, even after the Supreme Court had already explained how these cases were supposed to be decided. That is where this stopped being a small legal dispute and became something much bigger. Because once a lower court appears to go around a clear Supreme Court rule, especially during an active election, this is no longer just about lines on a map. It becomes a question about power. Who actually controls elections? The elected lawmakers of a state or unelected federal judges? So the state went back to the Supreme Court, not through the normal, slow process, but on an emergency basis, asking the court to step in immediately. And the Supreme Court did something rare. It responded fast. Within a short period of time, the ruling came down. The legislature's map was restored. The court-drawn map was removed for this election cycle. And alongside that order, the judges explained exactly why the lower court had gotten this wrong. And that explanation is really the heart of this entire story. The Supreme Court pointed to 3 specific mistakes. The first mistake was about something called the presumption of good faith. In simple words, this means that courts are supposed to start by assuming that a state legislature passed its map honestly, without bad intentions. That assumption can only be removed if there is real, solid evidence of wrongdoing, not just suspicion, not just disagreement. But according to the Supreme Court, the lower court did the opposite. It treated the state's normal legal behavior, appealing earlier rulings, defending its own map in court, as if that behavior itself proved bad intent. Think about how strange that is. Using your legal right to appeal a decision was treated like evidence against you. The Supreme Court rejected that completely. Appealing a court decision is not proof of wrongdoing. It's simply how the legal system is designed to work. If states could be punished just for defending their own laws in court, then every single legislature in the country would be at risk anytime they disagreed with a judge. The second mistake was about how the lower court applied the redistricting rules themselves. Remember, the rule was that a challenger's map had to perform well across all the legitimate factors, not just one. But the lower court appears to have focused mainly on the one factor that helped the challengers, while ignoring the legitimate reasons the state had for its own map: keeping communities together, respecting geography, avoiding unnecessary problems between districts. The Supreme Court's message here was simple. Partly following the rule is not the same as following the rule. If a court only checks one box instead of all of them, that is not a complete legal review. It's a shortcut. And shortcuts are not allowed when something as serious as an election map is involved. The third mistake is the one that really stands out, because it touches one of the oldest principles in election law. Courts should be extremely careful about changing election rules close to an election. This exists for a simple, practical reason. Last-minute changes confuse voters, confuse election workers, and create chaos in the system right when stability matters most. The lower court tried to defend keeping its own map by saying that election officials were, quote, already used to it, so switching would be more disruptive. But the Supreme Court didn't accept that explanation. Being used to something is not a legal reason. The real question was simple. Should a court-made map continue to override an elected legislature's map, once the legal basis for blocking that map has become seriously doubtful? And the Supreme Court's answer was clear. No. This is where the bigger meaning of this case becomes clear. States are not waiting around for federal courts to give them permission to run their own elections. Elected legislatures are not placeholders until a judge decides otherwise. When the legal reason for overriding a state's map becomes weak, a court does not get to keep its own version in place just because it's more convenient. And remember, this wasn't a narrow decision. It wasn't 5 judges against 4. It was 9 against 0. Every single judge, regardless of their usual differences, agreed on this outcome. That matters enormously because a split decision can always be explained away as one side simply seeing things differently. A unanimous decision is much harder to dismiss. Now, to be fair, there is a real counterargument here, and it's worth mentioning. Some people argue that switching maps again, this close to an election, creates exactly the kind of confusion that election law is supposed to prevent. They argue that if officials had already started preparing under one map, going back to another one creates real, practical problems. These are not silly arguments. They reflect a genuine tension that exists in election law. But here's the thing. Those arguments were heard, and they still didn't convince even one of the 9 judges. That tells you how strongly the court felt about the legal violations involved. So what does this mean going forward? This decision sends a direct message to every lower court currently handling a redistricting case anywhere in the country. Don't assume bad intent without real evidence. Apply the full legal standard, not just the convenient parts of it. And be extremely cautious before disrupting an election, especially this close to one. For states currently fighting similar battles over their own maps, this ruling gives them stronger legal ground to stand on. For election officials dealing with last-minute lawsuits, it gives them a clearer basis to push back against sudden changes. And for federal courts everywhere, it's a clear signal that going around Supreme Court precedent, even slightly, will not be ignored. But here's something important to understand. This is not the end of this case. An emergency stay like this is powerful, but it is still just the first stage. The deeper legal battle, the one that decides the long-term outcome, is still ahead. When the Supreme Court grants emergency relief like this and signals that one side is likely to win on the merits, that is never just a small technical comment. It's one of the clearest hints you'll get about where the law is actually heading. It tells you that the foundation of the lower court's decision is shaky, and that the state's legal arguments are strong. So the next few months matter just as much as this ruling does. What happens in the lower courts from here, how other states handle similar redistricting disputes, and how this case moves forward will determine whether this becomes a single one-time election ruling or whether it becomes one of the defining redistricting decisions of this era. Either way, one thing is already certain. 9 judges agreed, 0 disagreed. And this single decision is now being read carefully in courtrooms, legislatures, and election offices across the entire country. The state won this round. The legal rules behind that win are now sharper, stronger, and much harder for any court to ignore. And what happens next could end up being even bigger than what just happened. Make sure you're subscribed because the next update on this case is coming, and you won't want to miss how this story develops.